to give each of you 2 minutes right now, starting with you, Emily. What are the takeaways our attendees should keep front and center moving forward?
Okay. Do you mind going back to this last slide? I believe it's 30, slide 30, please. Okay, so I mentioned this briefly that because there are different injuries arising out of data breaches, there are different things a plaintiff can allege. And I think that's really the takeaway, that you need to consider arguments under all of the different potential injuries and not kind of lump it together into one injury. So I think that plaintiffs should first attempt to show that there's a concrete injury in the breach itself. And this is particular to data breach litigation, but it can be more general, that you should start with just the violation of the statute. And to do that, you should cite the cases like the Horizon Healthcare case where the court found that the violation of FCRA alone was enough, but with that additional analysis. The response to that by defendants would be to analogize to the zip code example in Spokeo and to say that the data breach was actually a bare procedural violation. And, you know, that depends on the situation, how strong that argument is going to be. I would say it depends on the type of data that's breached. If it's zip code that's disclosed, it's unlikely to be an injury in fact, but that is just one argument that could be raised in that situation. Then next, I think a plaintiff should separately argue a distinct injury that's the threat of future harm. The Con case, although the court found that there was no standing in that case, the court did say what the plaintiff would have needed to plead in order to find injury in fact in this case. And the two things are the actual examples, which I mentioned in response to your question about class actions, and noting that statistics alone are not sufficient. So some of the cases we saw, the plaintiffs attempted to quote that 9.5 times more likely statistic. That comes up a lot. And that alone is not enough. You need something more specific about the data breach. The second way a plaintiff can show a concrete injury is the clear indication that the breach was for the purpose of using the personal data to engage in an identity fraud. That example is the Neiman Marcus case where the hack was targeted towards the credit card information, unlike the Con case where it was a phishing scheme targeted at email. And then the defendant's response to that would be to argue under Clapper and Riley, which is a pre-Clapper case, but it's specifically a data breach case, that similarly said that it can't be too attenuated future harm. And that should be the argument in response, that the threat of identity theft is not actual or imminent. Again, that depends on the circumstances, but that's an argument that could be made.
All right, I'm going to get into secret word while we move back to slide 19, and that final secret word is allegations, A-L-L-E-G-A-T-I-O-N-S. Again, that word is allegations. Now let's move to slide 19, and we get our takeaways now from Bob Gaumont.
Thank you, David. You know, the first takeaway I want to do, I'm going to take these a little bit out of order because I want to talk a little bit about the last question that David asked, or one of the participants asked, one of the listeners asked, which was, has there been less litigation as a result? I think one of the big takeaways from this is that I think the district courts, without too much guidance, because the case is only 17 months old from the federal circuit courts, but the district courts are trying to get their arms around what this decision means in terms of what their ultimate result is. I don't think it results in less litigation when the different results that come from the district courts, if they do find a violation of Spokeo, is either a dismissal with prejudice or a dismissal without prejudice or a remand. The fact that you have three very different sort of approaches to that, district courts deciding it, and all of which I think are supported to at least some degree by the language of Spokeo itself, suggests that you could end up in state court. So I think the biggest takeaway for those of us who practice, who are inclined to cite Spokeo in our papers, is point 3, which is, a lot of the statutes that do not require elements of damages, like the section in FCRA which provides for a cause of action based on willful violations. It could actually result in state court litigation of federal statutes if plaintiffs make certain arguments and if the judge feels inclined to follow that line of reasoning. I think the second point that they're working backwards up here, there is the takeaway that the harm needs to be concrete and it needs to be particular. And by there, I mean, if you look at Spokeo, the Ninth Circuit decision, and I don't think it's particular to the Ninth Circuit. I'm not sure if the other circuits would decide it that much differently. You had a plaintiff who could say that they suffered concrete harm, meaning that their career was being misrepresented on the Spokeo website, and it was somewhat particular to them as well, because they were among the individuals who would care most about that because they were job seekers. So there is for plaintiffs, I think they got to focus a lot on the harm and the type of person that your plaintiff is and why it's specific to them. And then the largest takeaway that I really didn't appreciate until I started reading how the Supreme Court itself has cited Spokeo was that we present Spokeo because it's a concern to the folks who litigate in the financial services industry in that space. The Supreme Court looks at it more as an Article 3 standing case of application to at least now probably 5 different statutes, only one of which FCRA is financial services. So they're looking from a standpoint of you need to allege harm to be in court under Article 3, where we view it as financial services, and that leads to some of the results that we talked about before, where we could end up seeing a lot more state courts litigating federal statutes, which I don't think was anticipated by a lot of folks necessarily when Spokeo came out 17 months ago.
Thank you very much to Bob Gaumont, member of Gordon Feinblatt, and Emily Daly, attorney at Schneider Harrison. If you would like some free CE credits, please share your insights with us. We're doing a special research project to improve the knowledge group and better serve you. Give us 10 minutes on the phone. We'll give you 3 months of free CE webcasts. You'll find a link on the right-hand side of the main presentation screen that you can click on and sign up to be a part of it. If you requested a recording of today's event and or a certificate of attendance, you'll get the relevant information by email in the next 24 to 48 hours. Remember to follow the Knowledge Group on Twitter @know_group. This concludes our event, Understanding How Spokeo Affects Consumer Financial Litigation, the live webcast. If you've got a question for Bob Gaumont or Emily Daly, their contact information is in your event's materials. If you cannot locate it, not a problem. Send a request for their contact information to us, info@theknowledgegroup.org.